Good evening, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. We appreciate you being here. This is our Tuesday night live program. We're here for about an hour, and then we will go directly to our Patreon show for our true Crime Talk aficionados. True crime aficionados as well, I must say. So today, we have a couple of things I would like to talk about. First is Lori Vallow 2.0. She's been extradited down to Arizona from Idaho to face charges related to the death of husband number 4, Charles Vallow, who was ultimately killed at the hands of her brother, Alex Cox, who subsequently died of natural causes. That's their story, and they're sticking to it because there really wasn't an autopsy done. So it is what it is. Also, as it relates to the attempted murder of Lori Vallow's niece's ex-husband now, Mr. Boudreaux. So we've got that. And I've looked on the register of actions down there in Arizona, and nothing has changed. Just as we reported this morning in today's program, as it relates to a trial date tentatively being set, or it is set, but it could obviously be moved to April 4th of 2024, which isn't that far away, which is just 3 days after when her husband, Chad Daybell, goes on trial for the conspiracy of being involved with Chad Daybell, Lori Vallow, Alex Cox to kill J.J. Tiley, and Chad Daybell's wife, Tammy, first wife, Tammy. So interesting turn of events. Now we'll see if the trial will actually go as scheduled. Oftentimes these cases do get continued based upon court schedules, attorney schedules, things of that nature. But as I noted when we were talking today in our regular show, hey, if Lori Vallow is going to win this case, she needs to go on that April 4th trial date. That's the way to do it, okay? Every time I've had great success on a homicide case is when you go in the first trial setting. And why would I say that? Well, Lori Vallow knew she was going to get extradited back to Arizona at some point. Assuming the public defenders were going to represent her, they would be able to get the discovery. They would be able to begin their pre-trial investigation as it related to any witnesses that they needed to interview, any experts that they needed to retain. And so that matter, they should have had the last year or so. The indictment was returned on June 21st of 2021. So 2.5 years. You would think, hopefully, somebody down there in the public defender's office has been working on this, or they assign it to a private attorney to handle and to be ready to go so that they can say, let's do it. And let's face it, ladies and gentlemen, this is not a complicated case as it relates to Lori Vallow 2.0, right? We know that Charles Vallow had some concerns about Lori Vallow. They've been separated somewhat, so to speak, I guess. And Alex Cox goes over to the house to have a conversation, meet with Charles Vallow, and at some point an argument ensues, and Alex Cox shoots Mr. Ryan dead in his own house. Little weird, don't you think? Lori Vallow driving around, no big deal. When she finds out that her brother had just killed her soon-to-be ex-husband because she's going to go marry Chad Daybell in just a couple of weeks, she's very nonchalant. Very, very nonchalant. So, I mean, in all honesty, it's not going to take that long. What do you got? You got the police officers that arrive at the scene. You have them play the body cam video of what they know, maybe dispatch tape. Then you bring in the detective to talk about, what they did in the course of their investigation. And oftentimes the lead detective goes last to kind of clean it up. You bring in the coroner to determine how he died, cause and manner of death. apparently the bullet kind of goes in to Mr. Ryan there, or Mr. Charles Vallow, with the bullet underneath him that was recovered. And, say manner of death, cause of manner of death is a gunshot wound and homicide. There you go. You bring an expert witness to say that basically those gunshot wounds were not consistent with somebody coming at them with a baseball bat, and pretty much it. You got Lori Vallow talking there. I mean, is it the strongest case for a conspiracy to commit that? I don't know. I mean, maybe we obviously know she's a very cold woman, probably had some mental health issues. How was she supposed to react when somebody says that her ex-husband, who she was wanting to divorce, not be around, is dead? I mean, let's face it, ladies and gentlemen, if you had an ex, would you be that upset if they passed away? Let's be realistic. Who knows? Let's get this straight. Do I think that Lori Vallow is an innocent person caught up under the spell and mystery of Chad Daybell? No, I do not think so. But I think it's always interesting to look at what the defense perspective is going to be. And the prosecutors. Then you got the prosecutors. 404B evidence, all right? 404B evidence is evidence of other wrongs, acts that are brought in, not to show conformity therewith, but to show some other motive, absence of mistake, modus operandi. All right. And what I'd like to do at some point in the show is I get these case summaries, and it's a 404B case, and it gets reversed. And I think it just shows you how over the top 404B evidence can become, how they use it, and how the courts at the trial court level go along with anything nearly all the time, whatever the prosecution wants. Now, don't get me wrong. There is an appropriate time in place to show that other evidence is relevant to the conduct at issue. But remember, a defendant, and if you were the defendant, or if your family member was the defendant and charged with a crime, and maybe he had done some bad things in the past, but maybe this one he didn't do, wouldn't you think he'd have a right to be tried on these charges and these charges alone? Yes. And so, ladies and gentlemen, I tell you this not as a criminal defense attorney, but as somebody from the perspective that has seen a lot of 404B evidence and watched a bunch of poppycock it is most of the time. Usually, the more 404B evidence that the prosecutor intends to introduce, the biggest bunch of crap you'll ever see, and it shows how weak their case is. A good prosecutor doesn't need 404B evidence if they have good, strong facts. Remember that, okay? So let me just show you this example, okay? And then we'll come back to it. But I think this is I get case summaries, and this is a Colorado case, and you can go look it up. You don't think I'm making it up for you, but let me get here to it. Okay, this one is regarding the prosecutor's use of Mr. Woodruff's post-arrest silence to impeach his claim of self-defense was reversible error. Well, that's good. You can't comment on the defendant's silence, ladies and gentlemen. No way, no how. So let's get to it. This is an unpublished decision. And when appellate courts issue unpublished decisions, what they're really saying is, man, that judge really screwed it up so bad. We got to reverse this, but we don't want to be published because it's just so bad. We really don't want to do it. But this particular case is called People v. Clark, and it was a November 30th decision. Judge Roman reversed the La Plata County Judge Carlson. For those who don't know, La Plata County is down in the southwestern part of the Colorado. It's basically where the Four Corners is. It's Durango. Okay. So it says issue. The trial court reversibly erred by allowing the prosecution to admit evidence of Clark's 2007 conviction from starting a dumpster fire in this 2019 arson prosecution based upon Clark's alleged setting of a bag of chips on fire in a supermarket. Ladies and gentlemen, what do I say? You cannot make this stuff up. All right. So some facts. Someone set a bag of chips on fire in a supermarket. The government charged with Clark with being the culprit. At his arson trial, the government wanted to admit evidence that Clark in 2007 set fire to something in a dumpster. Issue number 1 presented to the court. The dumpster fire evidence was not admissible pursuant to Colorado Rules of Evidence 404B because the relevance of the evidence depended entirely upon the inference that Clark is an arsonist, right? 404B is evidence to get around saying you cannot bring in propensity evidence, which is prohibited under 404A of the Rules of Evidence. So we can read on. The district court conducted a Colorado Rules of Evidence 404B hearing and concluded that the 2000 dumpster fire incident established that Clark had an interest in watching fires burn, and this would establish his motive for the otherwise bizarre decision to light a bag of chips on fire in a grocery store. Once again, you can't make this stuff up. After hearing this evidence, the jury convicted Clark. The division reversed, finding the trial court erred in the SPOTO third prong analysis because the relevance of the evidence depends entirely on the inference that Clark is an arsonist. Well, there you go, right? The third prong of the SPOTO test, which is basically is irrelevant. We can go through that some other time, but basically that's the test that the courts are supposed to look at when they allow evidence in. Anyway, the court continues. The summary continues. The two fires were not similar. Well, they got to be similar to be 404B evidence. The 2007 fire was in a dumpster with only a single person other than Clark present. The grocery store chip bag fire was in a public location with cameras and multiple people present. Without more, having an alleged interest in watching fires burn is just another generic character trait that the defendant must be an arsonist. Now, the Attorney General came up with several other arguments that all ended in the same place, establishing that the defendant is a firebug, is impermissible in an arson prosecution. Issue number 2. The investigator impermissibly testified that her discovery of Clark's dumpster fire conviction was somehow part of her course of her investigation that led to Clark being a suspect in the bag of chips on fire case. Yep. So the DA goes back in for seconds, basically. Not satisfied with getting the dumpster fire evidence admitted under 404B, the district attorney argued that the detective, Kathleen O'Toole, needed to testify about finding the 2007 dumpster fire conviction to explain her course of investigation. The district court, of course, agreed because there has to be some sort of explanation as to why she goes there. Even though the judge provided a limiting instruction when O'Toole testified, the division found that this was reversible error. Caution is warranted when the course of the investigation exception is invoked, for it not a blank check authorizing the admission generally of otherwise improper testimony by investigators. And the propensity evidence that Clark was a firebug was simply too prejudicial to be admitted under this theory. On issue number 3, the trial court erred by allowing the prosecution to introduce as evidence the entire arrest affidavit that included the fact of Clark's 2007 dumpster fire conviction. So the DA goes back for a third try. Defense counsel cross-examined the detective about discrepancies in her arrest affidavit, but over the defense objection, the district court allowed the prosecution to admit the entire arrest affidavit, including the fact of Clark's 2000 dumpster fire conviction under the rules of completeness. This, too, was reversible error. Evidence admitted under the rules of completeness remains subject to the considerations of relevance and prejudice required under 401 and 403. As previously determined, the evidence was impermissibly propensity evidence and overwhelmingly prejudicial. These errors were not harmless. Not only was the jury repeatedly exposed to the impermissible evidence, the prosecutor emphasized in his closing arguments that the jury asked questions about the evidence. As such, there was a real possibility that the errors substantially influenced the jury. So it'd be interesting to see if the district attorneys down in La Plata County are going to spend tax dollars to retry the great burning bag of chips in the court system. It reminds me of my cousin Vinny. They went into the sack of suds to get wasn't a bag of chips from the sack of suds, something like that. I don't know. Anyway, that is a great example of the nonsense of 404B evidence. And I am sure I will bet somebody a large steak dinner that the prosecutors will intend to try to bring in 404B evidence in the Lori Vallow case, Lori Vallow 2.0, down there in Arizona, specifically the death of her children, JJ and Tylee, and even Tammy. So they'd have to try basically all that, bring in all those witnesses for that. What is that going to show? Propensity evidence. Now, think back to the Lori Vallow trial. And you can go back and listen to the Lori Vallow trial. We've got every day of hearing. What did the prosecutors intend to do? They brought in the case of Charles Vallow, citing that it was 404B evidence. And what did it really show? She's a killer. She conspires to kill people, ladies and gentlemen. It wasn't that, her husband just happened to die at the hands of her brother. It was a negative inference. And what did I say at the time? Judge should never have allowed it. But what happens? Prosecutors come in. Judge, we need this evidence. The burden that we have is proof beyond a reasonable doubt. It's the highest form of proof. We gladly accept this burden, but boy, it'd be a lot easier, Judge, if you let us have this evidence come in. And oftentimes judges will make these decisions, not because they think they're right, but they think, well, if I make this decision, maybe it'll be the one that makes the defense crumble and take the plea bargain so I don't have to sit through a trial. Little do they know, like the example I just read, the judge too weak to make that decision, make the proper one, keep the evidence out, right? It comes back and they get to do it all over again. Oh, and by the way, the guy gets convicted and sent to prison for a crime that he shouldn't have been convicted on because he was allowed impermissible evidence to come in. That is the classic example of why cases get reversed. Cases get reversed when judges and prosecutors make mistakes. And if the prosecutors in the Lori Vallow case, like I told you, how she can win it, how the prosecutors can win the Lori Vallow case is keep it simple. Keep it simple. Play the videos, play her arrival, her description. Keep it simple. That's it. Don't overtry your case. Let me tell you an example. I had a case years ago. I think I've mentioned this before. I remember I was young in my legal career in private practice, and it was a small county court case. And it was a fight that broke out at a quinceañera. A quinceañera is a party when a young lady becomes, what, quinceañera, 14? 15. Big party. I mean, it's a big deal. Dresses, food, dancing, big deal. Anyway, somebody shows up at the quinceañera that doesn't like somebody, probably the Uncle Joe gets a little drunk. I don't remember all the specifics, but needless to say, there's a fight. A fight breaks out, and of course, the police get called, and somebody's quinceañera was ruined, so therefore they wanted somebody prosecuted to the fullest extent of the law. Good to go. They call the first witness. Were you at the quinceañera? Yes, I was at the quinceañera. What happened at the quinceañera? Well, I was there, and guess what? There was a fight that broke out. Who threw the first punch? That man sitting over there in the corner threw the first punch. Really? Your Honor, will the record reflect that the witness has identified the defendant sitting over there as the man who threw the first punch? Yes. And then in true classic district attorney fashion, what happened next? Well, there was a fight. And what happened? Everybody got into a fight. Cross-examination. Ma'am, you can't really say who threw the first punch. Well, not really. It was crowded. It was busy. I mean, I think it was your client, but we're not really sure. Okay. So the prosecution gets up and calls their next witness. And they call their next witness. And like, ma'am, what happened? Oh, it was chaos. There was a fight. Oh, who knew what it started, but it was a mess. It was chaos. Defense attorney, me. Any questions? None, Your Honor. Prosecution not satisfied, calls, I don't know, 3 to 4 more witnesses to basically say what chaos it was. And by the end of it, the prosecutor didn't know what happened. And let me tell you what she said. She said, ladies and gentlemen, we may not know exactly what happened, but we have one witness who's pretty sure it was the defendant over here. Now, all those other witnesses that I called, don't really worry about them. They're not, don't worry about it. And I got up and said, ladies and gentlemen, and I remember the judge kind of looked at me and kind of winked like, what is she saying? I literally got up and said, ladies and gentlemen, if they don't know what happened, how do they expect you to know what happened? And you know what that equals? That equals reasonable doubt. Whereupon my client was promptly found not guilty. Okay. So the rule of that is, the lesson of that story is, don't overtry the case. Less is more. Less is more. And going back to Lori Vallow, keep it simple. You have people that can talk about the divorce that he had a hold, right? Because the fact Charles Vallow's statements will more than likely come in on the body cam because he's dead at the hands of the defendant, right? So it's probably coming in. So keep it simple. She wanted him dead. She wanted a divorce, and keep it simple. She got married 2 weeks later. And the way to get rid of it is this guy. The jury's going to know the rest of the story unless they're completely been, buried under a rock for the last 3 years, right? So there you go. Sally, was he guilty? Referring to my client? No, he was absolutely innocent. I mean, I have said this before, and I will say it again. My law practice, we have a very strict policy of only representing innocent people. It makes my life much easier, a little more stressful because, how do you represent those guilty people? Well, they're the easy ones. It's the not guilty ones that keep me up at night, the innocent ones. And when you have a practice full of all innocent people, what are you supposed to do? Right? I mean, it's very, very stressful. That's why I do my podcast show, to help me relax from the stress of representing nothing but innocent people. Lula says, I'm from Mexico. Was and still is a big deal. Yes. Quinceañeras, big deal. Yeah. Very big deal. So moments in trading. Look at her comment. Look at the comment. Laughing tears. Okay. If you've been around for a while with CrimeTalk, I'm being a little facetious there. Okay. But you get the gist of it. So anyway, we got Lori Vallow, how she's going to win, how the prosecutors can win. Keep it simple. Lori Vallow, go in there on this trial setting. Now, I think it does bring up some issues. Okay. Now, I would love to see the behind the scenes timing of this. Okay. The prosecution files a motion for clarification, basically saying, and this is in the Chad Daybell case, but says, hey, judge, we just want to make sure, is there anything from prohibiting the defendant, Lori Vallow, and her husband, Chad Daybell, to communicate with one another. Okay. Prosecution must have learned something. Maybe they thought they could charge him with some sort of witness tampering or violation of protection order, contacting a co-defendant when they shouldn't, because there was originally an order where the court denied Vallow, Daybell, and the attorneys sitting down discussing the case for the defense side of it, and possibly seeing like if somebody going to testify. So it really makes you wonder if there was some communication going on, and maybe Lori Vallow was going to testify on behalf of Chad Daybell, and the prosecutors in Idaho went and said, "Hey, prosecutors in Arizona, now would be a good time to come pick her up." Oh, what a coincidence. Your trial in Arizona is going to be set the same day that our trial set, basically making Lori Vallow unavailable to testify at the Chad Daybell trial. Now, wouldn't you... I mean, I've always said, if I was Chad Daybell's attorney, and I'm not, so I'm not giving him legal advice, but I would have gone in the first trial setting. But I think Pryor, and I know some people don't like John Pryor, but frankly, from what I've seen, he's the only one that did a preliminary hearing in the case. And frankly, he was a better attorney than the prosecutors that handled the preliminary hearing in the case. He really was. He made a couple of points. We all knew the case wasn't going to go away, but he's an actual trial attorney. He gets up and tries cases. He's not so scripted like the prosecutor. Asks her question. One question. Judge, we intend to introduce a PowerPoint slide to summarize the statements of our witness. Unbelievable. Why even have him testify? Let's just have him do his presentation by PowerPoint. Death by PowerPoint, ladies and gentlemen. Here's what I did, and here's what I did next. Boom, boom, boom. Unbelievable. Haven't seen anything like that before. Unbelievable. So, wouldn't it be great? I've always said, if I was Chad Daybell's attorney, I would have gone in the first setting and said, "Hey, ladies and gentlemen, I'm just a middle-aged guy going through a midlife crisis, and I meet this Lori Vallow, who, I mean, take a look at her. She's pretty attractive, right? And she liked me. She thought I was interesting because my other, wife didn't like me. Whatever. Make up any reason, whatever. But the relationship was strained, whatever. But one thing we know is that Lori Vallow was obsessed with Chad Daybell, and she would do anything to be with him. And we also know that Alex Cox was a bad, bad man. And even the prosecutors will have to admit through their testimony that it's likely that they believe that it was Alex Cox that killed JJ and Ty Lee. So if I was Chad Daybell, wouldn't you love to have the co-defendant come in, the one who's been convicted of conspiracy, to say and testify, there was no conspiracy with this schlub over here, Chad Daybell. It was all me and my brother, Alex Cox, because I wanted him so much. I wanted to be with him because I was crazy at the time, but now I'm fine. But it was clearly the bad Lori talking, right? That's how Chad Daybell could actually win this thing. Now, do I think there's some devastating evidence as it relates to the Chad Daybell case? Yes, I do. The one that I think is the most devastating is that call while he's sitting at his property across the street, watching the FBI and police authorities dig up his front lawn. And Lori Vallow calls from the jail. "Hey, honey, how you doing?" "Oh, good. Hey, the police are here." "Oh, what are they doing?" "Oh, they're digging up the front lawn." And her voice goes, "Oh." And there's that awkward silence, like, well, don't say anything because this is all being recorded. But they're both saying, "Oh my goodness," or words to that effect, right? And that, I think, and then of course Chad Daybell, once they realize that you're getting warm, those agents are getting warmer, they're getting warmer. They found the bodies. At that point, he drives away. Conscious guilt, okay? But I think Jack can make a couple of good arguments in the case. Man, she is crazy. Look at her. She's crazy. We know she's crazy because she went to the state hospital for 10 months, and then her attorneys had concerns about her competency. And Chad can say, "You know what? This lady was crazy. Her people were crazy. I stayed in custody the whole time because who knows what she could do because she's crazy. She kills people when she doesn't get them. I had to stay in good graces with her. I didn't kill anybody. Alex Cox did it. I had no idea. I maybe found out after the fact. I did some things that I wasn't proud of, but I loved her." And, he pleads guilty to accessory after the fact, or, he's found guilty of, desecration of corpses or something along those lines, which reminds me of another point. If I was Chad Daybell's attorney early on, remember when he was charged with the desecration of remains or something to that effect, whatever they call it there in Idaho? They had not yet charged the murder charge just yet. I would have done everything in my power to go in there and get the client to plead guilty to those original charges straight up. I've run into this recently as well, where I have a prosecutor's like, "Well, you can't plead guilty." No, my client can plead guilty at the arraignment. I don't need your permission. I don't need a plea agreement. Plea agreement is great, but if you're not going to give me one, then I'm going to plead guilty straight up, and sorry, sucks being you. So, that's what I would have done. And you say, "Well, Scott, what would happen if that had taken place?" Well, if they had pled guilty, my position would be is the prosecutors had evidence to believe that everybody was involved in the crime, i.e. Chad and Lori. And if they had pled guilty, jeopardy would have attached. And, if an attorney, it's one of the things the attorney has to figure out early on in the case is, okay, is my client guilty or not? Okay. I know it's tough. Maybe once or twice in my practice, I've had a couple of guilty clients over the years. And every now and then you got to get them into, into court quickly. Cap your losses. Okay. And if they had done that, I think that they would have had a good success of saying jeopardy is attached. Prosecution has to bring, there's a legal concept called compulsory joinder. If the prosecution is aware of a crime and they have to bring them all at once, bring all the crimes. Remember what they did with Lori Vallow? They brought her in for, some sort of neglect, abandoning the children. Once again, good attorney, go in there, plead them guilty. Well, you can't. Well, Scott, it's a different crime. Nope. You're saying the kids are gone. Nobody knows where they are. Kids must be dead. Reasonable inference, right? She could have pled guilty to abandonment of children. Then they bring in the desecration as it relates to Chad. Okay. Plead him guilty. You can't, under the theory of compulsory joinder, you cannot piecemeal cases. If you have the information, you need to charge it. If you're aware of it, you have to charge it. You can't wait until they plead guilty to one, or you're going to get enough evidence for the next one. And if they want to go and plead guilty, I think you got a double jeopardy argument. Now, that did not take place in this particular case because nobody did it. But if you were to go back and look at all of the videos that we did early on, I said, get in there, plead guilty. Argue that jeopardy has attached. Just something to think about, ladies and gentlemen. A unique perspective that you're not going to get from all the usual suspect talking heads on TV. Okay? You're not going to get that. Ange, good question. Kind of the 404B. I was wondering if they can use the way that the graves were dug. Chad was a grave digger. Well, Ange, if you had listened to the example that we brought, that I told you about a case that was reversed, that judge would allow the fact that Chad Daybell was a grave digger. They're going to bring it in that he likes to dig graves. And therefore it's not propensity evidence. But did we mention he's a grave digger? He must be weird. I mean, somebody's got to bury people, right? Somebody's got to dig the graves. But yes, that would be impermissible 404B evidence. But great question, Ange. I appreciate that. Let's see here. Oh, we a little sidetrack here. But we can do this because really jealous of the Casa Bonita. We used to have 2 in Oklahoma. A lot of the people that have never been won't get it. Yes. Now, was it yesterday, Frank, we put on? Yeah. Talking to Frank, the hardest working man in show business, producer of the show here. And yes, we went to Casa Bonita. That would be the lovely Miss Kristen and I and my daughter who flew into town with her boyfriend. And we used the prized and coveted link to get into Casa Bonita. For those who don't know, Casa Bonita has been around since 1973, and it's in a strip mall. It doesn't look like anything as you drive by other than, oh, there's a little pointy tower thing. But when you go in, you actually go down, 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 down. Put it in the video from Monday. And ultimately, they went bankrupt years ago. They've had issues, horrible food for the longest time. But it was the kind of place you always took the kids. You took friends and family that came into town. And then South Park made it famous. And they bought the place out of bankruptcy. I think they paid like $35 million. They cleaned it up, but it's still basically the same on the inside. And the food is much, much better. Okay. But they've done this weird thing where they haven't really started. They haven't started doing like everybody just walk in. You have to have a reservation. It's limited. And I'd say they're probably half capacity, which was good because, I mean, and the funny thing is, years ago, it started out as like a kid's restaurant, but it's all adults that are going in there. I would say I would have thought the average age in there was probably people in their, I don't know, mid to late 40s. It was just like that. And the lovely Miss Kristen. Scott was like a kid in a candy store at Casa Bonita. Jail photos, wishing well, Cliff drivers, all of it. It was fun. It was fun. I remember going there as a kid. I remember taking my kids there when they were kids, and now they're all done grown up, and they were back for it. So yeah. All right. So enough of that nonsense. All right. We're going to quit talking about that. We're going to talk about 404B evidence and the Lori Vallow case. All right. But thanks for the sidetrack there. But you can go check that video out. It was Monday. It's our bonus. It was like our feature, our field trip. We used to do field trips. And then sometimes you get really busy. And but I did not know that they had 2 in Oklahoma. I did not know that. I thought it was a Denver specific thing because, I mean, they got cliff divers. They had all this stuff. It was very, yep. Moments in trading. Yes, nailed it. They can't piecemeal the charges one by one. That's why Chad, I mean, I really think they should have pled guilty. I've seen it. A friend of mine had a case where it was some sort of alcohol involved in defense. They knew it was going to get bad, but they was only charging as a misdemeanor. And it's like, yeah, go in and plead guilty to the, DUI, careless resulting in bodily injury. But it turned out the guy had broken fractures. Go and plead guilty. Boom. Case is done. Oh, don't get to get a felony. Sorry. So yeah. And that's why sometimes why it's important for clients to be truthful to their attorneys. That's what it boils down to. That is what it boils down to. Is the food good at Casa Bonita? Lori Southern wants to know. It's better than it used to be. All right. I think everybody would agree that it was low-grade dog food years and years ago, but the new owners, it was actually delicious. I think I had some pictures in the video of it. It was actually very good. I'm not going to say everybody loved it. I'm not going to say you're eating in a Michelin star restaurant, but it was good. It was edible. I would go back, and this is not a paid promotion of Casa Bonita. We just went there, and it was good. And of course, we got Eric. Right? Was the picture with Eric? Was it Eric or Carl? Carl. Eric, I think.
Gutman, yeah.
Yeah.
Eric Gutman.
And lovely Miss Kristen, yeah, food is not delicious. I wouldn't say, like I said, it's not 5-star dining, but you're not going to a 5-star dining restaurant. It's a different experience. You went for the atmosphere. You went for the photos that you get to take with the little jail that you stand in with the little rubber thing. And, oh, look at me. It just brings back all those childhood memories. So, yeah. Can Chad plead guilty now? Well, it's a little too late for that, Darlene. And besides, we're looking forward to the trial. But he could plead guilty. But unfortunately, for him, that would subject him to the death penalty if he pleads guilty. My guess is he doesn't want to be found guilty, let alone be subject to the death penalty. So, I would just, I wouldn't. At this point, in all honesty, I think the prosecution has made this such a mess. All right. Not as such a mess as like the Delphi cases, which, we could talk about that for hours and hours and hours. That thing is a dumpster fire. All right. Maybe we should go back and look at other cases that the judge had in the dumpster fire, going to our 404B example and bringing that in. Well, the judge screwed up that case before. Look, she likes dumpster fires. She likes to watch fire. 404B evidence against the judge. But no, we want to see the trial in the Chad Daybell case. Only way they would take death off the table, and I'm not speaking for them, I have no inside information, would be that they would want him to plead guilty to get this over with, waive any appeals, waive any ineffective assistance counsel claims, do all that stuff, so that there's finality. Okay. Because like I said, I'm not a fan of Lori Vallow, but I don't like seeing people getting screwed either, because the Constitution does matter. Okay. Lori Vallow is more than likely, I think it's been determined, she is responsible for the death of at least 3 people directly that we know about, her own children, JJ and Tylee, and then the death of Tammy Daybell. So, there you go. She's a horrible person, but even horrible people have a right to, have their rights protected and given a fair trial. Like the 404B example, the guy's probably an arsonist, but it was in a supermarket with cameras around, but they didn't have anything. So they said, how can we come up with him? We know it's him. We got a hunch. Oh, did we mention that? Oh, good question here. The original Alexa, what is 404A? Fortunately, back here on our shelves, we just happen to have a copy of the rules of evidence. So let's read 404A, not to be confused with 404B. Sometimes it's always best just to read it directly from the law. All right. Rule 404. Character evidence not admissible to prove conduct. Exceptions, other crimes. 404A. Character evidence generally. Evidence of a person's character or trait of his character is not admissible for the purpose of proving that he acted in conformity therewith on the particular occasion, except character of the accused. In a criminal case, evidence of a pertinent trait of his character offered by an accused or by the prosecution to rebut the same, or if evidence of the alleged victim's character for aggressiveness or violence is offered by an accused and admitted under 404A2, evidence of the same trait or character of the accused offered by the prosecution. So if I go to say, I punched the guy, but he is aggressive, he's a bully and a thug, the prosecution can then introduce evidence of that to rebut aggressiveness or violence, and they can offer it to rebut anything like that. 404A, paragraph 2, character of alleged victim. In a criminal case, evidence of pertinent trait or character of the alleged victim of the crime offered by an accused or by the prosecution to rebut the same, or evidence of character trait of peacefulness of the alleged victim offered by the prosecution in a homicide case to rebut evidence that the alleged victim was the first aggressor. So you get to bring in peacefulness. If the defense says, oh, they're a violent thug, you get to bring in stuff saying, no, they were peaceful as can be. Okay. Doesn't really come in that often because you basically know. I mean, there's a lot of people that are innocent victims, but a lot of times the victims that the prosecutors get, they will tell you they're no angels. Okay. I know you're saying, Scott, isn't every victim in the criminal justice system, pure as the driven snow? No, there's some real piece of garbages out there that are labeled as victims. And obviously they deserve the same protection under the law, but prosecutors recognize oftentimes that their victims are pieces of garbage. Okay. So going back to 404A, paragraph 3, character of a witness. Evidence of the character of a witness as provided in Rule 607, 608, and 1390-101. Well, let's just, to be thorough, let's go to 607 and 608 and read it verbatim so no one can say I didn't do it. Rule 607, who may impeach? The credibility of a witness may be attacked by any party, including a party calling him. Leading questions may be used for the purpose of attacking such credibility. 608. Evidence of character and conduct of a witness. A, opinion and reputation evidence of character. The credibility of a witness may be attacked or supported by evidence in the form of opinion or reputation, but subject to 3 limitations. 1, the evidence may refer only to the character for truthfulness or untruthfulness, and evidence of truthfulness character is admissible only after the character of the witness for truthfulness has been attacked by opinion or reputation or otherwise. And then paragraph B, specific instances of conduct. Specific instances of conduct of a witness for the purpose of attacking or supporting the witness's character for truthfulness other than conviction of crime as provided in 1390-101 may not be proved by extrinsic evidence. They may, however, in the discretion of the court, if probative of truthfulness or untruthfulness, be inquired into on cross-examination of the witness concerning the witness's character for truthfulness or untruthfulness, or concerning the character for truthfulness or untruthfulness of another witness, as to which the character of the witness being cross-examined has testified. Clear as mud, right? The giving of testimony, whether by an accused or by another witness, does not operate as a waiver of the accused or the witness's privilege against self-incrimination when examined with respect to the matter that relates only to character or truthfulness. So what that says is you attack somebody saying, liar, liar, pants on fire, you're untruthful. You can bring in somebody and say, I've known this person for 8 years, and this person is the most truthful person I know. Okay. Well, we're not going to have a little mini trial about that, right? So basically, when that witness is called to testify and said, you think the person's truthful? Oh, really? Did he tell you about the, 2008 conviction that he had involving little children? No, he didn't know that. Did he tell you that he'd been to prison for robbing a bank and stealing little ladies' checkbooks? I didn't know that either. Oh, so really you don't know the person you got in here under oath to testify to that they are a good person, right? And truthful. Oh, no, I didn't. I guess not. Okay. One of the reasons why truthfulness character evidence rarely comes in a criminal case is because it's so messy. It opens up the door to so many things. And normally you don't want to bring in your character witness traits of your client. You want to keep them far, far away. Oftentimes, I know, even when you have completely innocent clients all the time, you still don't want to get into character evidence. You want to stick to the facts, okay? Then we have jumping back. So we looked at 607 and 608, which was referenced in 404, right? Because anybody can be a lawyer. How difficult is this? Clear as mud, right? And then 404B, other crimes, wrongs, or acts. Evidence of other crimes, wrongs, or acts is not admissible to prove the character of the person in order to show that he acted in conformity therewith, right? So in the example we gave earlier, the guy had an arson conviction where he set something on fire in a dumpster fire. Well, he was in a store possibly, even when there were cameras and we didn't see him, near the bag of chips that was set on fire. That's propensity evidence. But if the prosecutor can come up with some creative way and you get a judge kind of intellectually dishonest to allow it in, 99.9% of offered 404B evidence should never come into evidence, ladies and gentlemen. And I'm telling you, a prosecutor starts talking 404B, it means they got a weak case. Okay, not admissible, not to show in conformity therewith. It may, however, be admissible for other purposes, such as proof of motive. Okay. Opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, provided that upon request by the accused, the prosecution in criminal case shall provide reasonable notice in advance of trial or during trial if the court excuses pretrial notice on the good cause shown of the general nature of any such evidence of intent to introduce at trial. Okay? So those are all the other things, such as motive, opportunity, intent, preparation, plan, knowledge, identity, and or absence of mistake. And it must be specifically articulated. But what normally happens, the district attorney say, Judge, I want to bring in this dumpster fire incident, and I believe that it shows motive, opportunity, intent, preparation, plan, knowledge, identity, absence, or mistake. And they'll list them all. And the judge will be like, close enough. Defense, aren't you on notice that it's coming in? Oh, okay, Judge. Yeah, fine, whatever, right? And then don't you get this little other thing? Prosecution has to bring it in or has to give notice to the defense upon request of 404B evidence. But then it says, or during trial, will be allowed to bring in 404B evidence if the court excuses pretrial notice on good cause shown. And good cause shown is normally, well, the prosecution needs it to convict the guy or woman sitting at the defense table. And, that's the way it goes. So the rules apply equally unless the prosecution needs it. Now, maybe I'm just in a little bit of a fiery mood today, but that's just the way things generally work out. I was asked the judge, well, Judge, why are they bringing in this notice that's, this evidence untimely? There was a motions deadline that the court imposed, but they didn't impose it. We filed our notice of 404B well in advance, and now here we are 2 weeks from trial, and you want to or are going to agree to allow them to do this, even though the rules didn't comply. They didn't comply with the rules. And the judge would be like, well, Mr. Reich, why are you reading the rules? Okay. I'm going to find that there's good cause and they can do it. Well, just for the record, Your Honor, can I ask for what is the good cause for allowing the prosecution to bring this in an untimely manner? And the judge, well, I'm just finding good cause, which is code for they're the prosecutor. Okay. If you think it's not done that way, you're living in a dream world. You're being naive. It's just the way it is. Okay. I hope none of you personally, your family members, friends, are ever accused of a crime, and truly one where they didn't do it, or maybe they're not exactly guilty of what they're being accused of, because the rules are stacked against you. And even when there's rules, there's always an exception for the prosecutor. That's why I'm saying, ladies and gentlemen, I don't get impressed by titles. I don't get impressed by positions of power and authority. because most of the time they're getting a pass by somebody along the way, and they know they're not deserving of it or entitled to it in any way whatsoever. So let's see here. Oh, boy, how fired up. Don't get me fired up. We're arrested stealing a calendar. They each got 6 months. The tone of Chad's voice really made it that much more. That's referring to the call where Lori Vallow calls from the jail, and the police are getting warmer. Oh, you're getting really hot. Yeah. So anyway, that's my thoughts tonight for the Lori Vallow and a little bit of Chad Daybell. Lori has a better shot, I think, in Arizona than she does in Arizona or in Idaho that she had if she plays her cards right. The issue is also going to be whether they being her defense attorneys think there's some need for competency evaluation. Maybe that's mitigating to the prosecutor that she had been, in and out of mental. Maybe they run an NGRI type defense. It's going to be interesting, but I think those attorneys have had a couple years to get up to speed on the case. Hopefully they're not going to do the kind of a public defender thing and say, well, judge, she hadn't appeared, so we can't technically represent her until she showed up. We're going to need more time. I'd be like, are you kidding me? There's been an indictment for 2 years and you guys couldn't assign an attorney on a serious homicide case where your client's looking at a death penalty, potentially death penalty in Idaho at the time? No, they couldn't do that. So, all right, there you go, ladies and gentlemen. That's our Tuesday night live. Boy, did it go fast. We went by so fast, I completely forgot to do our obscene profit center commercials and ads, but I guess we'll do that next time. But if you are not a CrimeTalk aficionado, you should do so by going down to the link and joining, and because you get kind of some free cool stuff, and we'll send that to you. And that's right, we get to do our Patreon show. You can call in, which you can't do here. We do this occasionally, but you can call in. And of course, we're going to ask the Magic 8 Ball, Magic 8 Ball question of the day. Who knows what it'll be? We usually take questions from the audience. So hope to see all our Patreons there in just a couple of minutes. If you haven't become one, now is a good time to do it. Thanks for watching. We'll see you next time on Crime Talk. And remember, ladies and gentlemen, the Constitution matters.